defense rests, let's lay it down. Gonna dig deep, wave that verdict round. The defense rests, time to analyze. With the evidence, we'll unveil the crime. Justice served in an honest fight, true crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.
Hello, un momento. Oh dear, I've got music playing somewhere. Ugh, my mouse has gone spastic on me. Why have I got? Oh, what the hell? Where is this music coming from? I wonder if it's on the Karen Reid side. Hang on. Yes, it is. Okay, sweet. Sorry. Good morning. Good morning. Welcome. Welcome back. Welcome in. Welcome out. If you're new here, this is the Defence Rests. I'm Jodie. Oh, you look like you are. It's amazing what bit of makeup and some what is it? Touch up my appearance filters will do. If this is your first time here, please make yourself at home. Welcome. This is where we challenge the evidence and let you decide where justice lies. So we do a multitude of things here. Don't forget to click that like and subscribe. That'd be wicked. So today we have another motion. There's a notion for a motion to have a hearing to hear a motion. Yep. And if you know me well, you know how much I like Mr. Brennan and his dirty, underhanded, slimy behavior. I'll just leave it at that. Yeah. So I'd like to welcome Miss Tricia back. She's been unwell. She hasn't been on for a week and a half at least. She's been very unwell and we've missed her. So welcome. Thank you. It's good to see you again. Yeah. So this is the second part of this hearing that began yesterday. And we dealt with the defence's motion to not allow the Commonwealth's expert witness for dog bites because he is not qualified. Changing scheduling, the Commonwealth wanted sanctions imposed. They pretty much are requesting almost a blanket gag order on the defence. Hank wants every motion or filing to be presented to him first so that he can decide what needs to be redacted and what doesn't before it goes out to the press. He's trying to limit the defence team's ability to speak to the press at any time. And there is method to his madness. There is absolute. He knows exactly what he's doing. And he has a set plan for sure. Now, in my opinion, Karen's biggest, the biggest threats to the prosecution are her followers, for a start, so the public, her defence team, how strong they are, the experts, Dr. Russell for one, and the crash daddies for two. Now, Hank spent 2 days interrogating and intimidating Dr. Russell on the stand. He has put forward a motion to expel the crash daddies with a heap of unfounded accusations. So basically, what he did on the 13th of February was he decided that he was going, because he can't attack their credibility, obviously, because they're, you know, they're so experienced and impeccable. So he decided to attack their integrity and the defense team's integrity. So he presented a case that jumped around and jumbled the timeline up. So it appeared that the defense had not produced discovery, and that the defense had actually paid the ARCA witnesses during the trial, when they clearly stated in their testimony that they had never met, that they had not been hired by the defense, and they had not been paid anything, which was true at the time. But when he did his motion, he told the judge that there was no date on the invoice or the emails, and he wasn't aware of when the payment was made. Now, that date was important because the invoice wasn't issued until after the trial was finished, and it was actually paid on the 24th of July, which was 3 weeks after the trial had finished. And it was only after they had spoke, because the invoice arrived unbeknownst to the defense. They just finished their contract with the district attorney's office. So when they got this invoice, they were unsure what it was for, rang the district attorney, got permission to pay it, paid it. And that was 3 weeks after the trial. So they had passed that information over to Mr. Brennan, and he insinuated that he had gotten that information from the feds and had to go and what was it? What did he say? He said he had to use something. Can't remember what he requested, but it's a dark, dark road. It never sees the light of day. It was all theatrical. It was a massive publicity stunt, and it was designed completely to plant that seed of doubt in the public about the honesty of the defense team and the ARCO witnesses, experts. So what happened was, once he dropped that lie, Judge Bev basically took a recess and then came back and was clearly like, her hands were shaking, and she's like, I have grave concerns, and decided she was putting off everything for a week. So you can imagine what social media did with that. So all Hank needed was time, and who facilitated that? So the defense team weren't allowed to even have a response. So that carrot was dangled for a week. A week. So all of those clickbaits, all of those socialized, like the sensationalists, everyone, even opening statements got it wrong. They didn't check the date. So, in my opinion, the fact that the district attorney has brought in an external independent to represent the prosecution at the taxpayer's expense, $225,000. If that doesn't tell you that they're out to win, then I don't know what is. So, and looking at his, because he was the defense attorney for the Whitey Bulger case, and it's very similar in that he uncovered a great deal of government corruption, but was on the other side of the fence. So he actually had, if you read some of the articles from there, that he had a defense strategy And his strategy was to attack the credibility of the state's witnesses along the lines of their accusations towards him being a jailhouse snitch. And because he was vehemently against snitching, it goes against his code. He used that angle in which to create to attack their credibility, basically. Now, defense really shouldn't need a strategy. The facts should speak for themselves. And B, the prosecution is there to present a set of unbiased facts and evidence to the jury to make a decision, not to manipulate all of the defense's witnesses, to intimidate them, to lie, to cheat, to be underhanded. It's just slimy. It's slimy and it shouldn't happen, and it's wrong. I don't care if it could be Joe Blow on the stand. It doesn't matter if it was Karen or anyone else. His behaviour is disgusting, and he needs a chopstick in the eye. So, yes, that's where we're at. So the court, it's day 2 of this motions hearing. Now, she had this morning, I reckon it's going to be late, because she had her habeas corpus federal hearing today at 9 a.m. So court was set to start at 11 for this motions hearing. So they're probably running late from there. So I wonder how that went. That would be very interesting. Hopefully they can update us somehow. Actually, I might just have a quick squiz and see if there's anything. Seeing as we're waiting for court, there is nothing happening just yet. Let's have a look on the tube of the U, shall we? Oh, that reminds me, I should have put my PACER. Should have done my PACER registration. I've got my activation code and everything. I just haven't put it in. Oops. Oh, and if you were watching yesterday too, the federal investigation is not closed. It is ongoing. And Yannetti addressed that with Mr. Brennan yesterday afternoon. It was one of the last things they did. Day 1, day 2. No, I want federal. What's that? Unmute, Jodie. Unmute. All right, I will put this on. It's only a couple of minutes, but I'll share it anyway. Share this tab instead. Add to stage. There we go. Play.
Doug and Antoinette, good morning. Karen Reid's defense team says the jury was unanimous in acquitting Karen Reid on the charge of second-degree murder and the charge of leaving the scene of an accident with death resulting. Here's the background. After trial judge Beverly Cannoni declared a mistrial on July 1st, Karen Reid's attorneys say they were contacted directly by 4 of the deliberating jurors and had indirect contact with a 5th juror. Karen Reid's defense attorneys argue that there was no deadlock on counts 1 and 3, and she was, in fact, acquitted on those charges. Therefore, retrying her on those counts violates her state and federal constitutional rights against double jeopardy. Reid already lost this fight at the SJC. It is noteworthy that the jury did not fill out the verdict slips, nor did the jury indicate a partial verdict in any notes to Judge Cannoni. Today's hearing in federal court follows an important statement in state court yesterday. Special Prosecutor Hank Brennan confirmed to the court that the federal investigation into the death of John O'Keefe is complete. But after the hearing concluded yesterday, Karen Reid herself was questioning the accuracy of that claim.
We received a letter on January 30th from the first assistant U.S. attorney and said it was ongoing.
What about now? Do you believe Mr. Brennan?
Issues.
No.
If I take him at his word, that would be a very dangerous endeavor of mine.
Today is a doubleheader for the Reid case. First, there is the appeal hearing here at federal court, and then Reid's lawyers will head back to Norfolk Superior Court in Dedham to continue the pretrial hearing on motions which started yesterday. And depending on what happens with the federal appeal, Karen Reid could very well go back on trial for the death of her boyfriend, John O'Keefe, on April 1st. Reporting live this morning at federal court in the Seaport, Todd Kiskiewicz, WCVB News Center.
Try and say that 10 times.
Karen Reid and her boy.
Oh, what's that gone into? Federal probe. Probe. How long does this one go for? We may as well watch it. There's nothing happening.
Boston police officer John O'Keefe were bar hopping on a snowy night in Massachusetts. At the end of the night, they were invited to a house party at the home of a fellow officer in Canton, Massachusetts. When Karen and John arrived, Karen did not exit the car. John did. From that point forward, there are two very different versions of what happened. Prosecutors say Karen was mad at John and purposely struck him with her car and left him on the ground to die in the snow. But Karen and her defense team say John went to the party. Something terrible happened inside the house, and his body was placed outside, where he was found dead the next morning. Karen has been charged with murder, but claims she is the victim of a big cover-up by police.
Does it not, just thinking like logically and with a bit of common sense, okay? So let's just forget we know anything else about anything else. If you are a retired police detective, you've been in the job for 30 years, and you have investigated multiple crime scenes and all sorts of things, and suddenly at 6 o'clock in the morning you have fire engines, ambulances, screaming women, all sorts of a commotion, lights, you name it, on your front lawn where your bedroom faces on the top level, and you don't come out to see what the fuck's going on. That in itself just, yeah.
The battle inside the courtroom and outside the courthouse has been intense. Prosecutors insisting Karen Reid is a murderer, while she insists it was someone inside the house that night who was responsible for what happened to her boyfriend, John O'Keefe. And now reports that the investigators are being investigated by the feds. Tonight, we get all the latest as we continue our investigation into the death of Officer John O'Keefe. Excuse me. It's the weather, folks. I'm Vinny Politan. Great to have you with us tonight here on Closing Arguments. This is a case unlike any case I've ever covered. What is happening up there in Dedham, Massachusetts at the courthouse, in Canton, Massachusetts, where all this happened, the protest, the support for someone accused of murdering a Boston police officer. It's unreal. And every time I do this story, I get all these direct messages and notes, some of them a little heated from both sides of this controversy. No one is happy, and that tells me that this is different than most of the murder trials that we cover here, and that I've been covering for years. And it all begins as a Boston police officer, John O'Keefe. He's dead. He's dead.
Yeah, he is.
The question is, how did this happen?
Yeah.
Who is responsible? And obviously, as you heard, there are two complete.
All right, I want you to list this evidence, Udhef. List it for me. Tail light. Retrieved over a 6-week period from an unsecured crime scene. Dodgy footage, CCTV footage. In what? Why? Why would you mirror it? Head injury came from the back of the head. That's where the blunt force trauma hit, the back of the head. How do you hit the back of someone's head with a car and leave an injury that big? Lateral injury to the back of his head. And at the same time, twist around and somehow get your right arm scratched up. Just the physical position that would have to be in one motion of that car is impossible. It's impossible. No, it wasn't. Her car computer said she went 26 miles an hour backwards, and they couldn't retrieve any of the other stuff. And that doesn't measure the diff speed. It measures the tire spinning speed in the snow. And the fact that how many people have actually attempted to drive a vehicle in reverse at 26 miles an hour, couldn't even get it there to keep control over it, let alone achieve that in the distance provided. And then you add the rest of the rubbish. You know, why is there a federal investigation into this? The feds don't just investigate nothing. They don't waste their time. Why would they get involved? Why has there been so many issues with Proctor and Tully and Buchanan and the rest of them? Phone data shows that he got out of her car. No, he took 35 steps. Or he descended 3 flights of stairs up and down and 36 steps as well after that, after he got out of the car. And his body was 15 feet off the curb. And his phone was under him. No. Didn't happen. Didn't happen.
Different stories, versions, narratives of what happened the night that John O'Keefe was killed and then found dead in the snow. On the one hand, you have prosecutors saying that this was a crime of passion. These were two lovers who had an argument and she was angry and she struck him with her car and left him there in the cold to die in the snow. That it was about a relationship gone bad, and a woman who was angry, and that's why she did it.
She was angry because he didn't come back.
That's one version. That's what the prosecution has said. A lot of times you don't get another version, especially before a trial, but in this case you have. And the defense and Karen Reed are saying, no, it wasn't me. It was someone inside the house, and this was a police cover-up. It was a police party. And it was a investigation that was done by people connected to people in the house. And that's a problem. And it's a huge cover-up, and she's being framed for all of this. So there's a lot to get to every time we do this story. There's a lot.
Oh, shoot. Oops. How do I get back there? Sorry, Vinny. History. Oops. I have a spreadsheet of everything from
One of the local stations up there has been doing amazing work on this. Real big reveal that caught my attention, is catching a lot of people's attention. Take a look. 25 Investigates has learned that the Norfolk County District Attorney, Michael Morrissey, sent a letter to the Department of Justice. Those are the feds, folks, okay? So you've got the local prosecutor sending a letter to the feds requesting that the federal probe of the Karen Reed case be transferred out of Massachusetts. The feds up there are looking at this investigation. Morrissey's letter provides the first official confirmation that the U.S. Attorney's Office for the District of Massachusetts is looking into the arrest and prosecution of Reed. So in the middle of trying to prosecute someone for murder, the feds are looking at the people who investigated the case and investigated Karen Reed. This is highly unusual, but big news. Joining us tonight from Boston, Massachusetts, the investigative reporter at Boston 25 News, Ted Daniel, is with us. Ted, great to see you tonight. Unbelievable work and investigation you guys are doing. Before we get to all that, let me just take a step back. And your analysis of this story, this case, this trial, everything that's happening. I'm feeling down here in Atlanta that things are at a fevered temperature up there with everyone involved. What's your take?
Well, like you, I'm getting the same DMs and emails from people who are vested in this case. I've been doing this for 25 years. I've covered a lot of high-profile cases, including Aaron Hernandez, both of his trials, gavel to gavel. I've never seen anything as polarizing as...
All right, let's have a look at this. Okay, so this lists everything from January 28th at 7:30 p.m. all the way through. All right, so Jennifer McCabe arrives at 34 Fairview, receives a call from John, and it's deleted. Victim's phone data reflects a call to Jennifer McCabe. Victim's first ping in the neighborhood near 34 Fairview. Victim arrives at 34 Fairview. Jennifer McCabe texts the victim. She calls the victim, answers 8 seconds, deleted. Victim's phone data reflects a call from Jennifer McCabe. Colin Albert returns home. Jennifer texts the victim. Footage is missing from Canton Public Library at the precise time Karen Reed would have driven past it on the way home. Text, hello. Karen Reed, where's his phone data? Let's have a look up here. Phone location data. Come on. Come on. Open. Oh, maybe it's on this side. That one. Affidavit of Richard Green. In support of defendant's motion for order pursuant to Certified Computer Examiner with International Association of Computer Forensic. Following facts and information are based on my own personal records. Jennifer McCabe, John O'Keefe. The data images have been processed and reviewed with Celebrate, blah, blah, blah. Analysis of Jennifer McCabe's phone. Deleted call logs. There's John's. Analysis of John's. Okay. 170 steps. There you go. So at 12:21 to 12:24 a.m., ascended and descended 3 flights of stairs. At 12:31 to 12:32, 36 steps taken and nothing after. That's it. It stops. Notably, although the time range is indicated above, record total steps and or elevation during the relevant time period, it is impossible to determine whether the steps taken and or elevation gain was recorded during the entirety of that time period or for only a portion thereof. I subsequently analysed the location data associated with O'Keefe's iPhone to varying degrees of accuracy in order to analyse location data with this case. The location data was exported into the Celebrate application, allows the expert to filter based on accuracy, time, and location. For this portion of the analysis, I only relied on data that had an accuracy of 100 metres or better. Based on my analysis of the location data obtained on O'Keefe's cell phone, it appears that the first location ping in the neighbourhood near the Albert residence occurred at 12:19 a.m. Location data indicates that O'Keefe arrived at the Albert residence, 34 Fairview, at 12:24. In order to properly investigate, we need to obtain relevant time period. Furthermore, cell phone carriers independently maintain cell detail records. Yeah, okay, that's that one. What's that? Affidavit. Affidavit of Richard Green in support of defendant's motion for order pursuant to Mass Verizon. A data forensic expert. Following facts and information are based on my own personal knowledge. So this is Jennifer McCabe and John O'Keefe again. I think it might be the same thing, but just using a different program, perhaps. Let's see, what's John's? Analysis of John's phone. 12:21 to 12:24, descended 3 floors. 12:31 to 12:32, 36 steps. Same. What else do we want to know? The defense is full of nothing but lies against innocent people. Who are you talking about? The only person that's lied is Hank. No, she was pissed off with him because he was supposed to come back out to the car and let her know whether it was okay to come in, and he didn't. That's why she left all those nasty messages. If you've just killed someone, you're not going to send nasty messages to them, a voicemail. Now, Turtleboy attacks those children. At the end of the day, even if the defense lied about the date and the time and payment of an invoice, it doesn't change the facts of the case, and it doesn't change how John died. That's the way I look at it. They might have not done, and I'm not saying that they did, but they might have done something not procedurally right, but it has not affected the case whatsoever. The experts only testified to what they had submitted in their report to the federal government. They did not testify outside of that report, and that report was generated without any bias, without any knowledge of the case, and for a completely independent witness. So do you want me to look anything else up? Richard Green's popular. Was he a Commonwealth forensic expert or a defence expert? Must have been Commonwealth, I think. This is amazing. The person that put this together is just like, it's got linked to everything. Everything. Sergeant Lank. Time of death of John. Oh, yeah, he died at the hospital, didn't he? I wonder if this has got when they found. Where is it? Jennifer leaves her residence. Kerry Roberts behind Carrie's car. Jennifer McCabe arrives at 34 Fairview. She calls 911. Let's have a look at that. Oop. It's the same thing, I think. This is her search history. How long to die in cold. Search history information obtained from Jennifer McCabe's cell phone indicates that on January 29th, phone's user entered the following search in Safari. How long to die in cold. In order to confirm location. Was able to independently verify that the time, date, and fact of the search reported in Celebrite was accurate. I should zoom this out. Zoom this in for you. Oh, shit. Sorry. Oh, you can't see that. Shit, sorry. Sorry, I didn't realise that that tab didn't click open when I opened the affidavit to support it. Browsers. Visual tabs can be deleted by the user. Also perform timeline validation. The search for hustling to die in cold was entered at 2:27. Well, explain that. How long Ty died in Kirkwood? Hustling to die in cold. How long does it take to digest food? Deleted call logs. $18 deleted call entries between 5:33 and 8:50 a.m. on the 29th. At 6:07 and 6:08, she calls Coco, aka Nicole Albert, are deleted. At 6:23, call to Uncle Brian and is deleted. And then from 8:59 a.m., normal cell call log activities re-established. There are 17 calls listed on John O'Keefe's iPhone referencing Jennifer McCabe's cell phone number on the 29th of the 1st, attached here too. 29. Sorry, 17. There are 8 calls listed on Karen Reid's iPhone call log referencing Jennifer McCabe's cell phone. Of these 8 calls, only 2 are found in the Jennifer McCabe iPhone call history data. Deleted screenshot. Is that her phone? Yeah. All right, 12:18, she arrives at the Albert's residence, 35th Fairview. 1:47, she indicates leaving Fairview. 2:03, makes a right turn. And then 2:27 at 12 Country Lane. And that's when she does the search. It's exactly the same. All right. Let's go back and listen. Oh, where did that go? Share screen. Actually, I'll just check if the hearing started yet. Where is it? Where is it? Court TV. Read it. Wonder if Beth will be who you thought this was today. Just like the one who's being charged with murder. Really there to join the court TV community and promote updates from Court TV. Byron Wilson, it was a Court TV insider, Matt Johnson, said that the attorneys were in federal court this morning and it ran late, so we're just waiting for them to get to the courthouse. Okay. There you go. Might as well.
People are so absolutely dug in on each side, and that has led to just this firestorm that's existed since about April, when the defense came out swinging that they believe this is a cover-up.
So locally, how is this playing? Because now you guys have confirmed for the first time that there is in fact a federal investigation into the investigation of Karen Reed and the investigation of the death of John O'Keefe. Give us a little bit of the parameters of what this is about and what everyone is saying about that part of this case.
Yeah, we weren't the first ones to report the federal investigation. That had been out there, but we were the first one.
Can you say clearly that was not what happened when you're retrieving things 6 weeks after you're still collecting evidence on an unsecured crime scene? How can you say that that's not in the realm of possibility even? Prove to me that she hit him purposefully. How? I cannot put that car and that head injury and that arm injury all in one. It doesn't fit.
Ones to confirm it, and the way we did that was interesting. I got a tip that the Norfolk County District Attorney, who is the district attorney where Canton is, that he sent a letter to the Department of Justice essentially pushing back on this federal probe, that the Norfolk DA believes that there's a number of conflicts of interests that the DOJ failed to recognize and that they're essentially targeting him. So we did a public records request for that.
You know I'm open-minded. I've been, like, I even was right into the Zachariah Anderson. I had the theory, I had how he did it, I had everything sorted, and I was proven wrong. So,
letter. And when I got the denial from the Norfolk County DA's office, they denied it, saying, hey, this is confidential information. We don't have to give it to you. That essentially confirmed for me that, yes, we do have this letter in existence. This letter is here.
So at this point, where does everything stand? Do we have any idea whether or not people have been interviewed? Have people given depositions? Have people been put in front of a grand jury? What level of investigation is this federal probe at? Do we have any idea?
We do. Our sources tell us that there is a federal grand jury. We know subpoenas went out, and it's been going on for a long time, that subpoenas, at least one round of them went out on April 10th. A number of people who the state has identified as witnesses, who are going to be witnesses for the prosecution, they've been called in to testify in front of this grand jury. And we know that the grand jury was hearing testimony over the summer. I'm aware of people who testified in July and August. But I have have not been able to find or learn of anyone who's testified in front of that federal grand jury since August. And as you know, Vinny, these cases, the federal cases, they can take a really long time. But, there's so much, I think, thirst for information here that people are saying, hey, if the feds have something, if something really exists here that shouldn't, let's hear it. We want to know, because Karen Reed's going to be supposedly going to trial in March. I don't think it's actually going to happen then, but that's when she's on the calendar for.
Right. If the federal probe uncovers something, you would think that Karen Reed and her team would want to know what's going on there, because that would impact their case, because their whole case is that there was something wrong with the investigation and then it was some level of a cover-up.
Absolutely. It's hard to imagine that the feds would let the case go to trial if they have something, which we don't know if they do. If they have something, that the feds would let the case go to trial and play out that way, and then bring a resolution after that. Or if there's indictments, drop indictments after that. It just seems that there is, the timing of this is super important, and I wonder if the feds believe there is some pressure on them to wrap this up and reach a resolution.
And I want to get your take on what's happening at the courthouse, these huge displays. And I know I've had him on the show, Turtle Boy. I know there's a bunch of Turtle riders out there, his supporters, his listeners. But what's your take on this crowd? Is this his crowd? Is this people from the city of Canton who've gotten wind of what's going on? Like, what is really the genesis and the makeup of all these folks that are showing up at?
I've just looked up. Okay. There was microscopic taillight fragments found in John O'Keefe's shirt 18 months after that evidence was withheld from the defense that was found. Microscopic pieces. And we know that their chain of custody is crap. Black debris from grey long sleeve shirt, sample from areas around tears. And that was done in May 2023. Respective pieces of bread and clear plastic pieces of glass and a black straw recovered on 34 Fairview Road with the subject of physical match analysis by the trace unit. May 2023. Subsequently in July 23, trace analysis was performed on his clothing. So it's 18 months later. What's that? Incident report. It's not very clear. What's that? And explain the vomit. The vomit on his jeans. Cameron is not listed as a witness despite not being charged with any crime on this date. When's that? Can't see the date. 29th of the 1st, 2022. And then solo cups. Oh, that's the two items that were taken into evidence. Doesn't say what it was, though. Oh, broken drinking glass and 6 solo cups. Brian Albert's name is simply listed as B. Albert, the only person whose entire name isn't listed. Caitlin Albert and Tristan Morris are listed as witnesses despite allegedly leaving at 12:15. The list excludes Colin, Sarah, Proctor and Buchanan extensively interviewed bartenders and other people who were at Steve McCarthy's. Knew every move Karen Reed made at those places, but did almost no interviews with the people who were inside 34 Fairview. No taillight evidence listed because the Canton police did not find any taillight fragments when they searched the scene after John's body was removed. John's clothing was not entered into evidence until March 14th, 2022. The whereabouts of John's clothing were unknown between the 29th of January and March 14th. On several occasions, Karen Reid's attorneys have asked to inspect John's clothing. On May 22nd, Attorney Yannetti sent an email to ADA Lally requesting to inspect the clothing, which was ignored. As a result, they were forced to file a motion in August the 11th, 2022, to inspect the clothing, which was allowed by Judge Krupp. Still no action at the court.
At that historical courthouse.
Well, Turtle Boy's done a really good job of sort of galvanizing this large group of people. And I wouldn't say these are necessarily Cantonites. These are people from all over Massachusetts. And these are people who are...
No, they didn't get there magically. No, but they had 18 months to work out how to do it.
Incredibly passionate about their belief that this is a cover-up and that Karen Reid has been framed, and they're all over the state. You know, we cover a bunch of stories, but this is the story that people always come up and ask me, hey, what are your thoughts on this? What have you heard about this? There's something about this story that's just caught the attention of everyone here in Massachusetts, and I know that there's national interest in it too.
Oh, big time. Big time. So I want to take, since I have you here.
At the end of the day, cause of death, blunt force trauma to the rear of John's head. That's the cause of death. Now, that car did not create that on the back of his head. It's simple as that. Simple as that. It doesn't matter what anything else matters. No tail lights, no hairs, no nothing. No Sally Point finish. How did that blunt force trauma get to the back of his head?
I want to take advantage and go through some of the evidence in this case with you and get your take on this evidence and anything else that you know about it. Let's begin. I want to take a listen. This is Adam Lally, district attorney, talking about the cocktail glass evidence, which I think is extremely important for the prosecution.
The damages to the right rear corner panel of the defendant's vehicle. Embedded within the bumper to that vehicle is pieces of a cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video, external surveillance video from the Waterfall establishment that he left just prior to going to 34 Fairview.
You do, but not in one place and not in the back of your head. There's no bruising anywhere else. What position do you have to be in to sustain that blunt force trauma on the back of your head? Literally.
Fairview, with a cocktail glass in his right hand. Same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car.
So Ted, what's your take on the significance of this cocktail glass and the fragments that were allegedly found?
Yeah, the prosecution needs a way to explain what appear to be those puncture wounds on John O'Keefe's arm. And it appears that this might be a way that they're going to go about doing this, that John O'Keefe had this cocktail glass and when he was hit and it broke and somehow shattered or somehow dragged his arm. You're looking at the picture right there. And, you know, normally when something like having a cocktail glass would be that important, but I think as we see this case, when it goes to trial, I think that's something you'll be hearing a lot about.
And I heard the DA also...
If you look at that picture, you can almost see like that middle section there. That, to me, it looks like teeth. And these side bits here are the front claws where something went down in that house, and it had to do with Brian Albert because that was his dog. And that dog would have protected. Like John may have gone to throw a punch at him and the dog's attacked his arm. Who knows? Who fucking knows?
Argument there, Assistant DA talk about pieces of the glass in Reid's bumper.
That's exactly what they wanted. So the
prosecution theory is that she backs into him and then the glass breaks, ends up in her bumper?
No, that's Hank's.
Yeah, I mean, if they really do have a piece of glass that they found on her bumper, I think that's important for the prosecution. How else did it get there?
What was it? The the steroid hair that managed and the piece of glass that managed to survive a blizzard and stay on a tailgate.
I mean, I think that is something that I haven't heard a ton about, but it seems like a very logical path that the prosecution would want to go down.
Now, the other big thing is the tail light. Let's take a listen to the defense attorney, David Yannetti, talk about her broken tail light, which is another big issue in this case.
The tail light was intact when she left Brian Albert's house. She came home, and this was Karen leaving to begin the frantic search for John O'Keefe. Now, I don't know that you can see it from the video that you have there, but there is no doubt that when that SUV comes into contact with what is John O'Keefe's vehicle parked in the driveway, you can see that rear tire move forward. It rotates, and you also see the light shatter from the taillight being broken.
So I guess this is another issue in this case. Like, how does the taillight break? Does she smash it the morning after, or does she break it when she is running over and intentionally killing John O'Keefe? This will be significant as well.
I spoke to Karen Reed's parents. I did a sit-down interview with them a few months ago. And one of the questions that I asked her parents is, did Karen say she hit something?
The taillight was only cracked when she hit the Traverse. That even the police officer from the tow truck stated that in his testimony.
Remember hitting anything? And they said, yes. She said to her father, I thought I may have hit something. And their explanation is what you're looking at here, that Karen Reed backed into John O'Keefe's car that was parked in his driveway there. And they're saying, yeah, the taillight's broken because that's the way it happened here. The prosecution, if you look at their filing, they'll say that it appears that it may have touched the car, but it didn't really, move the car. We actually took a real close-up shot of that and spot shadowed it and slowed it down. And it does appear, as David said, that the tires do appear to move forward a little bit. Would that be enough to cause the taillight to break? I don't know. I'm not an expert on that. But I know that is certainly huge for the defense, this video right here.
Yeah, like what are the odds that you're accused of running someone over with the back of your car, and later that same morning or a few hours later, you...
That's red. That's red.
Back into a vehicle. It's going to be difficult for the jury to deal with that. Now the big thing, I know this is what set off Turtle Boy when I spoke to him, which was this Jennifer McCabe Google. Jennifer McCabe, one of the women at the party that night. Let's take a listen to Alan Jackson describe that piece of evidence.
Why is Jennifer McCabe one of the parties that was inside the house that night, the sister-in-law of Brian Albert? Why was she Google searching? How long does it take for a human body to die in the cold? The Apple Cocoa core data indicates, or the core time indicates exactly what time that Google search occurred. That time was at 2:27 and 40 seconds in the morning on January 29th. That's 3.5 hours before John O'Keefe's body was found.
I think for many people who believe that Karen Reed is framed here, this is the smoking gun, right? The allegation that there's a search about how long for someone to die in the cold at 2:27 in the morning before John O'Keefe is ever found.
Yeah, that's what that's what the defense led with. I remember the first day that they announced this bombshell change in the case, that is the evidence that they said they had. If you talk to the prosecution, they will tell you that there was a tab that Jennifer McCabe had open, and she opened that tab, and the search was actually conducted in the morning. And what the prosecution is saying is the search was conducted
apparently moments away. Court insider says Karen. Oh, here we go. Oh. Karen is inside the courthouse, just waiting for our cameras to turn on. All right, we'll switch over. 2025.
So the fact, what you state as fact, that Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have any access to those juries are the court officers in the Department of Security of the trial court in this courtroom. So I am going to ask you what your good faith basis is for that, and I'd like you to start there.
If the court recalls the discussion at sidebar,
I think so.
We were told for the very first time, Your Honor, about this issue concerning the juror and concerning the individual who reported information suggesting that there was some sort of misconduct at sidebar by the court with no additional information.
No, I didn't tell you about the role. I didn't know who it was.
I'm getting to that because that was the next conversation that we had. When we were told on the day of closing argument to approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion that there was some sort of misconduct by the jury, or by
I know you do.
We pressed the issue.
And I feel so strongly about the opposite. So,
for the first time,
all good.
We were told that Lieutenant Fanning
You were not, just so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well.
Yeah, shut up, Bev.
She's the one that indicated that it was reported. I'm sorry. That's not right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of one of the court officers.
Who are in charge of the jury?
Your Honor, I'm getting to that. I understand that. But if you'll allow me to make the argument and
shut the fuck up and let him talk.
As my declaration says, my good faith belief, based on reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration. There was no report. There was no supporting documentation whatsoever. No recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember. No, that was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused.
I will.
During that discussion at sidebar, that's when
Don't make too hard.
explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required. Period. End quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
and
he has.
I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us. We were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't, Again,
You were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was. Commander of the Extensive Security Operations of the Court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time, in good faith. Both Mr. Unetti and I asked the court to take evidence from Lieutenant Fanning. The court
I think it was
declined.
Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So, of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals, or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case, and he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that,
which you didn't allow,
that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did not.
Signed and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors.
February.
We received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access. He didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
So there, Bev.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson.
Fuck off.
Well, put it this way. Let's say it this way. So now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized? Now that you know it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously. clear.
So we will move on from that, Mr. Jackson. We'll move
You're a
on from
fucker.
that. So
the court
Let's not delve into it, fuck.
or what's our indication?
Don't worry about it. It's just
him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly witness. I'm sorry, defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason, because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case. And
Hey, Bev, she's a bitch.
Who knew? He ends up being the source of the information that got that juror removed. That's
she chose the
and yes, that's the foundation on which we built our argument.
What's the head juror's name?
He certainly never ever should have had any access, even in the orbit of the jurors, directly or indirectly, and the court never even inquired as to why he was the one
exactly.
Why Lieutenant Fanning, of all people?
She could have put that fire out straight away, but she didn't. Yeah, Bev actually selected the juror, the foreman herself, without any consultation to anyone else. Just Bev.
Straight line between
and apparently when that juror, like the one of the jurors came out and Turtle Boy interviewed him, he basically stated that the foreperson, when they were doing the jury filling out the verdict form, it was the foreperson that kept insisting that it had to be unanimous across the three things at the same time, not individually. Like, he would not accept that they'd agreed on the first and the third, but couldn't agree to the second. And it was the foreperson that was saying, no, it has to be all the three. And the jurors actually asked him to ask the court, and he wouldn't do it.
Who has an interest in this case?
And he was the one that filled out the verdict form, or lack thereof.
In our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
Yep.
all right, so that's your answer to my question.
That's my answer.
May I have a moment to confer with counsel?
Yes.
Sidebar already. Sidebar. Yeah, no, she's in it up to her neck. That one, she absolutely is. It's been fireworks in these motions, Tricia. Like, if you go back and watch it, he just blatantly lies. He just lies, and then she goes off. Bev goes off for a 10-minute recess. And she comes back and she's like, you can see her hand shaking with her glasses. And she's like, I have grave concerns. And she just jumps to the worst conclusions without even finding out any further evidence, not even asking a question.
The court invoked Mr. Unetti and said, as local counsel, he knows this not to be true. Mr. Unetti just indicated to me that that's not quite the fact. And so Mr. Unetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Unetti. So if the court would allow Mr. Unetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with.
Oh, you fucking bitch! See, she's not even interested in listening.
Thank you for giving me the opportunity. The cumulative discovery.
You can't tell me she's not biased.
Commonwealth, as laid out in our moving papers, through their agents, has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers. But I want to concentrate my argument for the court this afternoon on the exculpatory Sally Port videos. I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think I think it bears upon the court at this point to consider most prominently the Sally Port issue.
She denied them a forensic copy. which had the metadata.
Two facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not.
They've just gotten some more video evidence now.
They also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. Well, they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it. Conveniently, they throw much of this on the back of Michael Proctor.
The fall guy.
He's already damaged goods, so why not? And they also bring in a newly revealed sergeant, a sergeant by the name of DG Petro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious. So he's still around?
He is.
Okay.
Yes, and it's cooperative.
All right. All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations. And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition of Miss Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Sally Port at Canton PD is of critical importance. And that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor. Police. That is the foundation on which this is built. And it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Sally Port video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got two videos. One was the Sally Port interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Sally Port. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Sally Port interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant DG Petro retired, we received four videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Sally Port. And I highlight the word exterior because it becomes extremely important in just a moment. These are four videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022. Then on January 28th, 2025, the Canton Police Department main driveway side exterior Sally Port was given to us. That's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Sallyport video that we ever received. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick, dated February 28th, which is 5 days ago now. And he makes an important admission in that report for the very first time.
Sorry. I just found something really funny. I just was looking at because Ty was supposed to do another live tonight, so I've just got onto his site, and he's got the Pro Se Revolution shorts, and he's put up mine for the dipshit judge. And this one, John Travis Johnson gets cranky on cross-examination. Oh, that's funny. Judge dipshit. Love it. Love it. How can I like that? Oh, that's funny. Sorry. Please resume. Sorry, Mr. Jackson.
During trial,
sorry, Miss Jackson.
He was provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, "At this time, I reviewed the video and made available. I reviewed video made available to me, which included video footage of the Canton PD exterior Sallyport. Exterior Sallyport. That means that the Massachusetts State Police not only had in their possession exterior Sallyport video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 2025, and they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination...
So can I just ask, was this of better quality than anything you had, or was it the same wobbly?
Same.
Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Buchnick admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Sallyport video? We now know that Buchnick watched some sort of exterior Sallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024, because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Sallyport video and intentionally withheld it from us. This is binary. It could only happen one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Buchnick was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute, on April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, that the fact that those videos all just happened to either be grainy wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the sally port. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to, yes, I will get to the prejudice as I move through.
Now or no? If you can, if you're going to do it later, that's fine.
I will do it later. I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided. It just very obviously. There were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them. On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession, and that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true? And we're still getting video evidence that is in their possession, custody, and control in October, in January. How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But in point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had attendant to their opposition was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Sally Port videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a...
I just always like to read along. Where does it say it?
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs,
okay.
Crime scene photographs in support of the vehicle in the Sally Port. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sally Port. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years before it was turned over to us. So it's the condition of the car at the time that it was brought into the Sally Port on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought into the Sally Port. And we're still talking about the condition of the taillight, obviously, when it was brought into the Sally Port. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sally Port at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41, 11 minutes, long after the car had already been secured in the Sally Port, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. It's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote unquote evolving. They write that the defense quote struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Sally Port, is in fact exculpatory. How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the Sally Port. How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video, it's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits. Those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time. So the Commonwealth battled us, and this is something I think the court has to really weigh and balance the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the Sally Port. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, some of them under oath. And all the while they were battling us on the time that it got there, no, the defense is all wet, they're wrong, they just didn't account for daylight savings time. Oh, no, this was just a little mistake, it's not a big deal, it was a Scrivener's error.
Hello,
and
baby.
the entire time they're making both of these claims, they had video in their possession that established unequivocally that car was in Michael Proctor's possession at 5:30 and pulled into the Sally Port at 5:30. They knew the time. They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the Sally Port until 5:30. So the Commonwealth was well aware in 2022, the Commonwealth and their agents were well aware in 2022 that the SUV got to the Sally Port, and that was the centerpiece of the defense case. They knew that the videos would directly impeach the lead investigator on this case, and they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle. to explain it. It's their struggle to acknowledge it. Of course, that's exculpatory. It directly and unequivocally impeaches their lead investigator on one of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the Sally port, would it show the condition of the taillight before Trooper Proctor had access to it in the Sally port? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. This is not a game of Wordle. This is not something that's supposed to be parsed. All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in the business of withholding exculpatory evidence by playing some sort of a gotcha game with definitions of words. They knew what we meant. We don't actually know what the Commonwealth has, so we have to be as broad as we possibly can when asking for evidence to be preserved. So all physical evidence clearly includes the entirety of all the Sally Port videos. The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sally Port because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed. I think the Commonwealth is better than that. That's not what we should be doing in a trial for murder. And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, D.A. Morrissey said, oh, he was talking about Canton PD, which is the crime scene. So they can't have it both ways. They write on page 4 of their opposition, quote, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sally Port until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor, end quote. So they've taken the position, look, we personally did not know anything about that Sally Port video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case. Not one, but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does. The Commonwealth cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department, by saying, I personally didn't know about it. The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581. And this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation. And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor. Persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence. Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sally Port where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Butnick and of Sergeant Buchanan and I arriving in the main entrance around 5:30 following the vehicle. Question: when did you watch the video from the Sally Port? Answer: I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
I can get them for you, Your Honor. I
Okay.
didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish, that would be helpful for my review.
I haven't reviewed it, sir, in quite some time, so I can't recall what's on there. Question: why did you review video of the Sally Port? Answer: we review every video we pull. We pull a lot of video. It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Buchanan. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight. And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact: by his statement, Michael Proctor admitted that, quote, we pulled, end quote, the video. That video is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C is in Charlie.
Okay.
The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But you have to have pulled the video within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. Hasn't been years. He further admitted that it shows the SUV arriving in the Sally Port at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video, that was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says the, quote, trial prosecutor, end quote, was not aware. It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents. The fact that the trial prosecutor, whoever that is, it's an interesting use of a name, of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this. But that's not a defense. Who is the trial prosecutor? Is it Adam Lally? Is it Laura McLaughlin? Is it both of them? And why are they only referring to one trial prosecutor when there were clearly 2 in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit that was supplied was a type of affidavit I've never seen before, where it's signed under oath by 3 different people. So which sentence goes with which person under oath? The single declaration is odd, to say the least, but it certainly doesn't define who's responsible for what statement in that declaration. We certainly know that it was not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote, but claimed that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal materials.
Were those all from the Canton Police Station?
I'm sorry.
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about the Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
The prosecutor had not been alerted to its existence by investigating officers, but on April 4th, they promptly presented it to the defense. The Commonwealth actually received the materials that highlighted the fact that these existed in February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt. We presume that Mr. Lally has daily communications or had daily communications with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time. And it took 2 months to produce an incomplete production of these videos. We didn't even get all of them at the time. The Commonwealth writes, quote, "The quality of the video is poor in certain portions. However, this is the condition it was recorded in." Says who? That's a fact question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in? We've got no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered. And these questions could be answered with a proper evidentiary hearing. The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton Police video system. We were not told that until well after trial. That was never disclosed to us. And I think Mr. Brennan used this phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed to as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was quote unquote defective. Interestingly, that's the only video that's clear. It's inverted, but at least it was clear. And that's the camera that, according to the Commonwealth, was replaced as defective.
Oh, sorry.
After filing its certificate of
Hungry kitty cats.
after the defense brought to the court's attention that 42
What I miss?
missing from the Sallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except, as the court now knows, that's the one that was inverted. In the moving papers,
I still on that.
the prosecution says, well, the prosecution did not previously receive this video or knew of its existence. This is now the third or fourth time that the Commonwealth sort of runs to this argument. I didn't know. We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much longer are you going to be?
Probably.
She's a bitch. Let him have his argument.
45
It's a woman's life, for fuck's sake.
We'll break.
Well, for once, I made it just before the break. All right, let's go and have a search, shall we? I reckon. So are they breaking for lunch or? Oh, my hip. Will be under tea. What about Truth Behind the Treehouse? It's funny that, yeah, he did his first live last night and it's been taken down. And he was going to do a follow-up tonight with answering questions and nothing. What time is it over there now? What is it? 1 or 2 o'clock? 1? All right. Let's see if he said anything. Are you doing another live? Actually, if it's only 1, that will be a 6 p.m. thing, I would think. Let me see. Are you doing another live? Did you know that your stream